Maybe I should shut the door. You ready to go? Okay. Good morning, everyone. This is Susan Francis, the Deputy Director at the Maryland Volunteer Lawyers Service. We're doing this training both in person and via the webinar, and everyone should be up and able to see our screen and hear us. If you're having problems on the webinar, go ahead and type anything in, or a comment in the questions, and we'll try to keep an eye on that just to make sure everything is running successfully this morning. But with that, we're going to go ahead and just jump right in and talk about expungements this morning. In addition to myself, Chris Sweeney is also going to be presenting today. Chris runs our workforce development project and literally helps hundreds and hundreds of clients every year file expungements. So Chris is really the resident local expert when it comes to all things expungement. So we're going to talk about some of the basics of expungement and then talk about some of the changes. One of the good and bad things about expungement law is since 2015, every year there's been changes that have expanded the ability in terms of being able to expunge records. The downside of that is it gets a little bit more confusing and in a few cases a little bit more nonsensical every year. And so we're going to talk about some of those today as well. So with that, we're going to go ahead and jump right in and see if this works. Okay. Make sure there's nothing here. All right. So why we do expungement? MVLS really stepped into substantially started doing expungements in 2015, and that's when there was a really substantial change in the law that lets us expunge a lot more records than we could previously, and it was really dramatic. So in 2014, we expunged we helped about 7 clients. The following year, we helped over 700. And so that gives you a sense of kind of the dramatic change in the law. And every year since then, we've continued to help hundreds and hundreds of individuals all across the state be able to expunge items from their record. And the reason we do it is because of the items that are listed here. Having something on your record serves as a barrier to all of these. And so since we work with low-income clients, we're looking to remove as many barriers as possible for them to move forward with their lives. A lot of folks don't know that any involvement, any prosecution at all ends up on your record and shows up on case search. So many folks think that only if you were found guilty it's going to show up on case search, and that's not true. Any proceeding whatsoever. And so we have a lot of folks that have a number of things on their record in which they were never actually found guilty of anything. But what happens is third-party companies scrape the data from Maryland Judiciary case search, and that's what employers use for background searches. That's what landlords use for searches for housing. And the landlords and the employers are not going to go look at every record and make a determination, well, was that person found guilty in this case, or were they not? Were they acquitted? They're going to see that someone has, 3, 4, 10, 15, 20 touches with the police and just make an assessment about them that they are criminally involved without ever really looking to see whether that person was indeed found guilty of the things that they were charged with. So that's why we do this, because we're, trying to particularly remove employment barriers for individuals. So in terms of what we're talking about today, so expungement is really just removing the criminal cases. We get this question a lot about, can I get my judgment? I had a creditor who got a judgment against me. Can I expunge that? Can I expunge my divorce from public, from public search? Can I, expunge? And the answer is no. We can't expunge these civil items. It's really just criminal items. But when we talk about criminal items, that includes the kind of criminal things that you would think about, but it also includes some traffic cases and includes civil citations as well. Like we've had some interesting ones, like one of the most interesting citation ones I've seen is a person got a citation for not wearing a life vest from the Department of Natural Resources. And so we can expunge those as well. The other thing to keep in mind is we're only talking about Maryland cases here. So we also get questions from clients. We don't expunge any federal records, and the answer to that question is federal criminal cases really aren't expungible, and we don't look at any other state issues. So if someone has something going on in, Virginia or Delaware or somewhere else, they really need to go address that in that state. We're really only here looking at Maryland cases. And so this is just sort of give you a sense of how significant this issue is. So this is just looking at Baltimore City District Court, because the reality is many people get sort of involved in the criminal system, and most of those cases end up not being found guilty. And so you can see this was some numbers pulled from a couple years ago that 60% of all Baltimore City District Court cases were eligible for expungement. And that the numbers that were eligible, so the 23,000 plus, and only about 8,500 petitions were filed. So every year we kind of fall farther and farther behind between what's expungible and what's actually getting expunged for someone. And then you can see we have a tall order there. As of 2014, there was over 1 million expungible cases just in Baltimore City. And so this is an illustration of what we're really talking about, how many eligible expungements there are. So this is a very small part of Baltimore City. It's near our office, and every one of those little dots represent an expungible item on someone's record. And so you can just see it's just kind of an overwhelming amount of individuals that we could be helping with expunging items from their record. Okay, now we're going to jump right into talking about the law. And so these are the two most relevant areas of the law. So both in criminal procedure 10-105 for non-convictions, which is what we're going to talk about first. And then 10-110, which is going to be the convictions that Chris is going to walk us through in a few minutes. And I should say this presentation, the recorded version we're going to be putting online, but this actual presentation that we're walking through today is already online, and we'll show you where it's at the end of the presentation. And for the individuals that are on the webinar, it's already, the PDF version of this is in the handout section, if you want to take a look at that or grab it while you're still on the webinar today. So the first thing we're going to talk about is the non-convictions. And so the first thing is if it's the general rule, the almost always but sometimes not rule, is that if you didn't get a conviction, then it's likely going to be eligible for expungement. And so, just to clarify, conviction equals guilty. That's what we're talking about. So we're talking about guilties and then everything else. And so we're going to talk about everything else first, and then we'll talk about the occasional exceptions when we can actually also expunge a guilty conviction. So these are the non-convictions that you're going to see, and we're going to walk through each of these. And they're kind of listed, I guess the next one we'll go through is like the best disposition. So we'll go through these in the next couple of slides. So here's the best, and best means they're the simplest and most likely to be expungible without any real caveats. So the no proseque is where they were charged, but the state's attorney decided not to prosecute. Of course, you've got not guilty and acquittal, dismissal, and juvenile transfer. Those are all pretty straightforward, expungible. So these are the only, or I guess the two things to keep in mind here. For these particular dispositions, we're going to go through an example in a minute, but one of the things that I get sort of caught up sometimes is just remember, you're always looking for the disposition in the case. Sometimes it's easy to see what the individual pled, and you're like, oh, they pled not guilty. Well, what they pled doesn't really matter, right? It's what the actual disposition is. And so, so if you see one of these dispositions, you can file for expungement immediately. There's no waiting period. However, there is an additional requirement. If it's within the first 3 years of their disposition, you have to file a general waiver and release form. And essentially, the individual has to waive their right to sue anyone that was involved in that entire incident, from the police to the prosecutor to the judicial system. And the idea around that is because we are asking the court to expunge all of the records that then if that person turned around and sued them within the 3 years, which is the statute of limitations, they wouldn't be able to appropriately defend themselves because they have expunged the records. So what we do when we have a client within that 3 years, we say, this is your option. You can either wait the 3 years and not sign this form, or you can sign this form. This is what the form is doing. It's going to waive your rights to sue. We are not criminal attorneys. We're not advising you on whether you should waive that right or not, but these are your options. You either sign it or you wait the 3 years. And I don't know about you, Chris, and the entire time I've done this, I've had one person. Have you had any that have decided not to?
I've had zero people who didn't want to sign it.
Yeah, and I've had one. So, because, you know, the option, they're there to get it expunged, right? So, and most folks are not planning to sue for any kind of recovery. So we don't advise them about whether they should sign it. We just tell them these are your two options, and then they can decide. So here's the first example of, you know, what you're going to look at. So this is from Maryland Judiciary Case Search. And as I mentioned, you know, you can see the plea there, other plea. A lot of times when we're working with a client, they'll be like, oh, no, it was a not guilty. And it'll be like, no, you pled not guilty. But really what we need to be looking at is the disposition. And so in this case, you can see disposition is nol proseque. And then the second thing that you need to look at then is the disposition date. So we can see that this disposition date was in 1999, so we're well past the 3 years. So you don't need to file that general waiver and release. But you want to remember for these, you're always looking at both disposition and the disposition date, because when you're looking at a record on case search, there's a lot of different dates floating around. There's the filing date, there's dates of different proceedings, but we're always looking at the disposition date. And so you can see there, we have the very high-tech arrows pointing at, that's the disposition that you're looking at, and that's the disposition date that you're looking at. Okay, so the next one we're going to look at, so you've got your first three that are just immediately expungible. You don't really need to do any more analysis other than do you need to file a general waiver. The next disposition is a stat, and as you can see, that's eligible 3 years after the disposition date. So you don't have to do any other analysis around whether this is expungible other than has it been 3 years. And I think the example is on this page, right? So here we want to look at, first you're going to look at the disposition. So if you go down there, you can see that's a stat. So all we have to say is, has it been 3 years? And then we're going to go over right beside it and look at the disposition date. And you can see that's 1997. We're well past that. And this is something that then is expungible. And you don't have to worry about filing a general waiver and release for this one because you've already waited the 3 years. So just by the nature of the 3 years, you've resolved that 3 years statute of limitations.
Susan, is there any good faith exception to that 3 years for that one? Like there is for PBJ?
that I'm aware of, no. It's possible that it could happen after 1 year, because as I understand, the stat is sort of a temporary postponement of the charges, and the prosecutors do have the right to bring back the charges within a year for no reason. And then if it's been more than 1 year, they would have to petition the court to allow them to bring the charges again. So maybe if you were 2 years, you could try to argue for an exception for an early expungement, but I haven't seen that happen.
Yeah, and for other folks, we had the question about the good faith exception, which we can talk a little bit, comes up sometimes with the probation before judgment. The challenge, both with potentially a SED and the probation before judgment, you can request a good faith exception to the waiting period. I will say, I think the bar, it depends on sort of the jurisdiction and the judge. The bar can be pretty high because sort of the argument you might be making for your client would be the same argument for almost every other client, right, in terms of, this is a barrier to employment, for example. Occasionally, if we can provide some pretty clear proof that this client, for example, this client, an employer would offer this client this particular job but for this particular, like we had an individual who, an insurance company wanted to hire her, but it just was their policy that she couldn't have anything on her record. And they, as soon as we removed it from her record, they hired her. So in that sort of case where you can prove very specifically, depending on the jurisdiction and the judge and the day, sometimes you might have some success there. And the intention of this stat is sort of to say, we have a good amount of evidence that you may have committed this crime, but we're going to give you a chance and sort of put this on a waiting docket. And if you sort of repeat any activity within those 3 years, they're going to come back and convert it to likely a guilty conviction. Is that a fair?
Yeah.
Yeah. Okay.
Yeah.
All right. So those are kind of the simplest dispositions, and here forward, gets a little bit more complicated, and you have to start looking at things that any subsequent activities from these dispositions forward. And so here we have the probation before judgment, and again, it's 3 years after the disposition date. So it's very similar to the stat in that you're looking for that 3-year period. The difference is with the stat, you don't have to worry about any subsequent conviction. With a PBJ, you've got to look to see what else has happened within that 3-year period. So if someone has a probation before judgment, there's sort of, you can see here 2 exceptions. One of them is if they, and this is the only charge that there is, right, for a PBJ that isn't expungible just as its own charge.
Right.
So the probation before judgment for DUI or DWI is not expungible. So that's the only charge type, only crime that is just not expungible as a PBJ in and of itself. If it's a DUI or DWI, you don't need to do any further inquiry. That just is not expungible. The second exception is the subsequent conviction rule. And that's where you really got to say, so if you have someone that has a PBJ, you've got to look to see what has happened in 3 years since there to determine if there's any conviction. So again, conviction is going to equal guilties. And so you're going to look in that 3-year period, see if they have any guilty convictions, and then you've got to figure out if that guilty is expungible. And if it is, then the PBJ is also expungible. If that guilty is not expungible, then you also cannot expunge the PBJ. So we're going to look at some examples here. Okay, so here's one demonstrating the PBJ for DUI. And so you can see it's driving under the influence of alcohol. The plea, again, it's easy to look at the plea, so you just kind of got to discipline yourself to go to the next one, which is the disposition, and it's a probation before judgment. But we don't have to go any further because it's a DUI and it's a PBJ. This is not expungible, and so that's just no. There's no waiting period. There's no other inquiry. That just is not expungible. Okay, so this is working with the subsequent conviction rule. So you're going to look at the first case, case 1, and you can see the charge is assault second degree. You can see the plea is guilty, but again, we're going to look at the disposition, which is probation before judgment. And so then the next thing we need, so it's not a DUI, so we have to say, okay, was there a subsequent conviction? So you can see the disposition date is 10/7/2009. And so you're going to go out and look and see, well, does this person have anything else within the 3 years? And you're going to disposition date to disposition date. And you can see there's the second case. So you've got a murder second degree. The plea was guilty, and the disposition was sentenced with a verdict of guilty. So the disposition is a guilty. And you're looking at the verdict date, which would be the disposition date. And so that's 9/10/2012. So even without math being my strong suit, I think I can do that math to say this individual cannot expunge this first item because it's within 3 years. So if that verdict date was 9/10/2013, and so it would be after that 3-year period, that assault second degree would be expungible. But because it's within that 3 years, both of those items, both the assault second degree and the murder second degree, are going to stay on their record. Does that make sense? Okay.
I have a question.
Yeah, of course.
So if instead of a guilty verdict, there was another PBJ,
Yes.
does that prohibit the first PBJ from being expunged?
You have to look out again the next 3 years.
Okay.
So it just sort of extends out.
So it wouldn't prevent the first one from being expunged?
If the second one can be expunged. So the question is, so say that murder second degree, the disposition was a PBJ. So we would say, okay, the assault second degree, the PBJ, we're going to go out 3 years. Now, if that second one is also a PBJ within the 3 years, then we got to figure out the 3 years from that second one, because we can't determine if that second PBJ is expungible until we look at the following 3 years. So it just sort of because then we would have to, so say there's a case 3 and it was another murder second degree charge with a guilty within that following 3 years, then that's going to block all of them. Because the first PBJ can only be expunged if there's nothing else going to be in that following 3 years. So if we got a following PBJ within that 3 years, then we got to figure out if that PBJ is expungible from the following 3 years. So you just kind of got to look out a little bit further to do that analysis. Okay, and I think, Chris, we are getting close. So there you go. There's the dates that we're looking at there. So the 2009 to 2012. And now, I'm going to turn this over to Chris with convictions. Before we jump into convictions, are there any other questions about the non-convictions? And if you're on the webinar, we are monitoring questions as well. So if you do have questions, please feel free to type them in. Any other questions that any of you have about the non-convictions? Because it does get a little bit more complicated, so I want to make sure we've got a good grounding before we go on. You all on board? Yeah? Okay. All right. So Chris, I'm going to hand this over to you. So let me slide this over.
All right. Hey, everybody. Again, I'm Chris Sweeney. I'm a staff attorney here at MBLS. We'll continue on talking about which convictions might be expungible. So this is something that's relatively new within the last couple of years, that certain convictions have been carved out to be potentially expungible. And it is less common to find cases with guilties that can be expunged, but it does happen more and more as they continue to expand eligibility for expungement. So we've broken this down into 3 basic categories for instances where someone was found guilty of a charge. So there's no waiting period, short waiting period, and long waiting period. I think I'll hop over to the next slide and break that down in some more detail. Actually, I'll jump back real quick and just explain that the no waiting period is only for if you were convicted of something and then later in time the act that you were convicted of doing is no longer considered a crime in Maryland, then you can just file for an expungement immediately. There's no waiting period for that. That is pretty much just possession of marijuana, less than 10 grams, which was decriminalized several years ago. And I'll also add as a quick tidbit, going back to the probation before judgment talk, if you were to receive a probation before judgment for marijuana less than 10 grams or something else that's no longer a crime, there would be no subsequent conviction rule. You would be able to skip that analysis. So then there's short waiting period. That is mostly what's carved out in the statute as nuisance crimes. And you can see examples of common nuisance crimes that we often see with our clients. We certainly see the drinking alcohol in public or open container and things like that. And we see a lot of the eating food on transit, playing music on transit, not paying transit fare, loitering, and things like that. The rule with that is if you were found guilty, you have to wait 3 years, and then it can be expunged. I would note and emphasize that there is no subsequent conviction rule for nuisance convictions. So there's an example of a nuisance crime, and when you're looking at a client's case on case search, what I do is always go right to the disposition. I would just go right to the disposition first without thinking about what the charge is. So you see it's a guilty, and then you start going through, okay, well, does it fall under any of the exceptions? That's when you look at what the actual charge was, and you can see urinating in public was the charge. And you can actually just Google Nuisance Crimes Maryland. The court actually has a pamphlet that just lists all of them, and you can easily compare the charge and see if it's on that list. So you'll see that it's a nuisance crime if you do that, and then you would see that you just have to look at the disposition date, and there would be a 3-year waiting period. So there would be March 9th, 2020 would be the date that you'd be able to expunge that one. So we've got the marijuana, which is broken into something that's no longer a crime, and then just possession of marijuana, which could be more than 10 grams. It usually isn't. Now, this is a little bit confusing because when the crime no longer a crime went into effect, there were a bunch of people with marijuana convictions that were usually less than 10 grams, but it happened before they started specifying whether or not it was 10 grams. But at this point, it's been so long that you're not seeing that many clients who actually have the conviction for possession of marijuana, since usually it's under 10 grams. If you get caught now, you wouldn't be actually getting charged with a crime. But if you have someone who just has the charge of possession of marijuana, usually you don't have to go into whether or not it was 10 grams, because if it has been more than 4 years from the date of disposition, then that case is expungible. So that's another instance where it's simply a 4-year waiting period. There's no other analysis, and there is no subsequent conviction rule for that conviction either. You might run into an instance where a state's attorney would object, or even the police department who reviews every expungement that gets filed, might recommend an objection. That seems to happen, I think, based on just a misunderstanding of the law. Because if you were convicted of possession of a drug that wasn't marijuana, there would be a subsequent conviction rule. But there is definitely not one for just possession of marijuana. And that is regardless of any amount. The statute doesn't even contemplate what amount it would have been. So that question's irrelevant.
Yeah, so I was just going to add, I think to Chris's point, the crime no longer a crime no less than 10 grams took effect a couple of years ago. So that's more the court and the state's attorney and the police recognize that one. But the 4-year waiting period for marijuana possession just took effect last year. And so sometimes you might still find the courts or a state's attorney that are not yet aware of the one on the left side, the marijuana possession with the 4-year waiting period. But there's no doubt about whether it can be expunged or not. It's just sometimes you might have to educate.
Right. And then I'll quickly add that if you do encounter a client who has possession of marijuana conviction and it has not been 4 years and you want to help them expunge it anyway, you can usually get proof that it was less than 10 grams. You would just have to contact usually the police department in the county where the case happened, and you can get a police report, which usually details that information. So there you just see another case search example of possession of marijuana. You see you have a disposition of guilty, and then you just look at the disposition date, and if this was a real client you were sitting down with, you would see that it's been more than 4 years, and that's the only charge in the case, so you can file for expungement of that case. So now we have the long waiting period, and now this is jumping into Criminal Procedure 10-110, which we often for shorthand call JRA, because this particular statute was rolled into an act called the Justice Reinvestment Act, which was a comprehensive act that didn't just cover expungement, it covered other issues that deal with people coming home from prison and other issues like that. So we often call these JRA crimes for short. So I might say that as we go forward, just so you know. But these are, I believe, all of the types of charges that are carved out in 10-110 as being potentially eligible for expungement if you are found guilty of them.
That apply to our clients.
That's true. That's true. There actually are a number of other less common crimes, usually white-collar crimes and other things that have to do with, like, fraud in real estate, and gambling on horse betting and stuff. These are the convictions that we see our clients getting the most often. I will note out of that list, you'll see prostitution. And if you see a conviction for prostitution, I would note that the 10-110 actually carves out only specifically a conviction for criminal law 11-306A. That's the only charge for prostitution that is potentially eligible. And as I understand, there actually are a number of other statutes criminalizing different forms and levels of prostitution. So you want to double check if you see that it does fall into only that specific statute. So the waiting period that we're calling long is 10 to 15 years, and these are broken down within that list. Trespassing, drug possession, drug paraphernalia, those are 10 years. Theft is 10 years if it's a misdemeanor, and recently felony theft was added, and that's 15 years. So I think going forward, there's a little bit more of a breakdown there. Yeah, so there are the 10-year, those are the 15-year waiting periods that you're now seeing on the screen. And I'll note felony theft is usually as a shorthand way to identify that on a client's case. If the charge says something like theft less than, say, $1,000, then it usually is a misdemeanor. If it says theft more than 1,000 or 500 or another figure, then it's usually a felony. And that figure would move up or down just based on when the case happened, because the threshold for when it was a felony has been raised over the years. And then burglary, another kind of strange caveat to note there is that as it stands now, the way the law is written in Maryland is that first, second, and third degree burglary, which are all felonies, fall within this potentially expungible list. And then fourth degree burglary, which is a misdemeanor, is currently just not expungible as a conviction. That's something that we believe will be added next legislative session. That was probably just an oversight, and certainly is kind of contradictory, but right now that's how the law stands at the time that we're recording this webinar. And then when we start talking about the waiting periods, these get a little bit trickier than just the PBJ 3-year or the marijuana conviction 4-year. What you actually have to do when you're looking at subsequent convictions for these, not just subsequent convictions, but just the waiting period itself, the waiting period of 10 or 15 years actually doesn't begin until the end of the sentence. So I think we have some examples of that coming up. So you have a guilty here for second-degree assault. Now that's a 15-year waiting period. But you'll see that there was a probation of a little less than a year. So the disposition date was 11/2/2009. There was a suspended sentence, so we don't count that. We look at when the probation ended. So the person was on probation until August 9th, 2010. So in this case, the 15-year clock doesn't start to run until August 9th, 2010. And there's that date pointed out for you. And then that would be plus 15 years from the 2010 date. That would be how long this client would have to wait, assuming that there's nothing else blocking expungement of that case, which we'll get into. And what would block expungement of these convictions would be subsequent convictions. So if you get a subsequent conviction during that waiting period for any particular case that you had, the analysis would be, is the subsequent conviction eligible for expungement or not? So in this example, you see the same case that we just looked at with the second-degree assault. And remember, we had to wait until 2025 for that waiting period to be up. But this person got a robbery conviction in 2015. So a robbery is not on that list of potentially eligible convictions. So that is a case that is just simply not expungible. And because there is a not expungible case within that waiting period, that means that the initial case we were looking at, the assault, is also not expungible. And this is sort of breaking down an example of a timeline and how this all stacks up. So if you have one case that is a conviction that falls within the exception, so this is misdemeanor theft, So that's a 10-year waiting period. And then you get another conviction within that waiting period, but that conviction also falls within the exception. It sort of tacks on another waiting period. So you go back, you have to wait until whatever the most recent conviction that you got, you wait until that case can be expunged, and then they both become expungible. And it looks like we might have a question here.
Question. No, I don't think so. I saw the hand, but
Right, okay.
yeah.
If you do have a question that you wanted to type in, go ahead and try to type it into the question box that you should see on your screen. So victim notification is something that's written into the statute for these JRA expungements or 10-110 expungements. This is just a statutory requirement if you file for expungement of one of these types of convictions. The court is required to notify the victim in the case. Now, a lot of times with our clients, it's going to be just drug possession, so that's irrelevant. But if it is something like a battery or a second-degree assault or burglary, there is a victim notification requirement. What it says in the statute is the victim has the right to object to the expungement, just like the state's attorney or another party might want to object to the expungement. And they would be able to offer their reasons why they believe this person should not get this case expunged. In practice, I haven't seen this happen yet. I think that from a practical standpoint, if it's been 15 years or more anyway, the person may not live at the same address that they did when the case initially happened, or the person might just not bother. So that's something that is the letter of the law, but I wouldn't worry too much about that actually happening if you were to file one of these.
I have a question.
Sure.
When there's victim notification, do you get, or does the client get copies of the victim notification and the response, if any?
I would think that, well, the victim is notified that they should send something in writing to the court. And then probably the court would schedule a hearing. I think the court, there is not a statutory requirement that I'm aware of that the court has to send that out before the hearing. I think that a lot of courts probably would. Some courts just might, it just might not happen due to high volume of stuff going through.
I was just wondering if you have the opportunity to respond to their response.
Right.
I mean, it's a little bit unknown because I've never actually seen this happen. I mean, I don't know that they would specifically, they should share whatever the objection is, right? You would be, and hopefully at least be informed that there was an objection because there's going to be a hearing. But yeah, we haven't actually seen one, so I'm not sure.
Right. So I think that that's a thing that would probably just be up to the individual court. There are little variations in court practices.
But I guess it would be advisable then to check the docket.
Right.
Then after the period of time has expired to see if anybody did respond.
Right.
Because it should be part of the docket.
Certainly. So we have a question from someone watching remotely.
Although, let me just, yes, good to watch the docket, but in some jurisdictions, they don't enter the expungement proceedings
That's true.
in the docket.
So, like, for example, a lot of Baltimore City District Court,
Yeah.
almost never updates case search with recent happenings in the case. So that's not always the most reliable. But a lot of other counties do keep that updated. And that sort of relates to the question we have here, which is, does it matter if the subsequent conviction is from another jurisdiction, and how would that be dealt with? The simple answer is no. Pretty much across the board, whenever you're doing any of the analyses that we're talking about today, it doesn't matter where the case happened in Maryland. So if it happens to be a different county or a different court level, district or circuit, it doesn't change anything about the analysis that you're doing. We will probably talk a little bit toward the end about maybe some little...
So just to clarify, so if it's out of state,
right,
it doesn't matter. If it's in state, any subsequent conviction in any jurisdiction has to be considered. So just,
right,
to Chris's point, district or circuit, in any county, anywhere in the state, you have to do the analysis. If it's out of state or federal, doesn't matter.
right.
Maybe over there. There you go.
Okay. So another little component to these 10-110s that's similar to the victim notification is that this is the only instance where there is judicial discretion to grant or not grant the expungement. If you look at 10-105, the section that Susan was talking about, if there's not according to the letter of the law, if there is not an objection from the state's attorney, the court shall grant the expungement. In the case of these long wait convictions under 10-110, like the assault second degrees, the drug possession that's not marijuana, battery, burglary, etc., the court does have the opportunity to make an inquiry into whether or not the person is a risk to public safety, whether or not the person has been rehabilitated, the nature of the crime, and then would have to determine that the expungement of that case is in the interest of justice. Again, this is something that I have not seen happen. This would probably just be triggered by a victim objecting or a state's attorney objecting for some reason. In the case that there is no objection from any party, these cases just go through the procedure at the courthouse like any other expungement. So again, that's something that I wouldn't worry about too much when you're going to file one of these cases.
And is that the same section of the Criminal Procedure Act?
Yeah, that's listed in 10-110.
Okay.
All right.
So I'm going to turn it back over to Susan for a minute to talk about some more complications in doing this analysis.
All right, so we've covered non-convictions. Chris just covered convictions, like you said, that we call the JRA items. And then this just adds a few more wrinkles to the process, just to keep it interesting. And then Chris is going to walk you through some examples so we can work with some of the, what we've gone through so far. So one of the principles you have to apply in every expungement analysis is a thing we call the unit rule, and that applies to every single case that you're looking at. And the unit rule means when you look at, it's rare, we've been showing you examples where someone's just in charge with one item. That's pretty rare. What normally happens is someone is charged with multiple items within one incident. And so you have to determine if all of those charges are expungible. Because if there's even one in there that isn't expungible, that means the entire case, everything associated with that incident is not expungible. So you can't kind of choose and pick and say, well, this was a nolle pros, but this was a guilty in the same case. I'm going to expunge the nolle pros, but not the guilty. Everything in that incident has to be expungible. And so one of the things to take a look at, you can see here it says it's all charges arising out of a single incident. Usually that it's one case, but sometimes they can split into different cases. And there's really kind of two places that we see this most commonly, where it's split into two cases. Every once in a while, we'll see this in a criminal case, particularly if it's gone up to circuit court. So if it's a district court case, they sometimes break that district court case into two circuit court cases. And so you need to look at that district court case and the two circuit court cases. It's not very often, but every once in a while, you'll see that. Where you will see it all the time is when you're looking at traffic cases, because traffic cases order, their format is every charge is a different case, but they'll be numbered very similar. So it might be like FA01, FA02, FA03. And so you can look at both the format to which it's named, but also the dates to see what all is within that incident. So it would not be uncommon, for example, if you have someone that has traffic and say they have a suspended license, they also got speeding, and they also have no seatbelt. Each one of those are going to be its own case. And so you want to look at all three to make your determination. And so these are two examples where we're working with the unit rule. So in example one, you can do, so I'm the opposite of Chris. Chris looks at the disposition first, which is a very logical way to do it, but I'm too curious. I always want to know what the charge is first. So I always look at the charge first, and then I look at the disposition. And so you can see this is the same case, same date. And so in this, they were charged with both malicious destruction of property, where they have a guilty, and then they also were charged with that assault second degree, which was a not guilty. So this is how the unit rule comes into play, is that, you look at that, now you say that assault second degree, that's a not guilty, and you're like, ding, 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 I know that that is expungible. But because it's associated with this guilty, with the malicious destruction of property, then you've got to go on and do some of the further analysis. And Chris, I'm drawing a blank here. I know malicious destruction of property is shieldable, but is it expungible?
I think it is in 10-110.
Okay.
So it would be a 10-year.
Okay. So in this case, you would say like, okay, assault second degree, yeah, but I've got to deal with this malicious destruction of property. And Chris has said that it is a 10-year waiting period. Assuming this client doesn't have any other charges, that one would not be expungible. And let's see, there's no jail term, there was no probation until January 20th, 2020 is when you would be able to expunge example one. And then under example two, again, you're looking at everything that's in this case. So you see the first one is a not guilty. Second one is a stet, so that's looking good. So both of those, are expungible. But as always, we have to look at the disposition date. And you can see that's a 9/25/2017. And because we all know now that stets have a 3-year waiting period, this one would be expungible on 9/25/2020. So they would have to wait until then to be able to expunge this case. One of the other things you have to keep in mind is there cannot be a pending criminal proceeding. And by pending, essentially, we just mean it's active, they're currently being prosecuted, there is no disposition in the case. So you can see here, probation and parole does not count as a pending proceeding. So literally, I have had clients that have some sort of charge, and I'm like, well, call me the day of or the day after the judge gives you your finding, and then I can file whatever they might be expungible for. So they actually could be in jail, they could be on probation, whatever the sentence is, the disposition, we just need it to be concluded. And so what that means is no pending criminal proceeding means we cannot file anything for them until they don't have a pending case. So I may have like 10 things I can expunge for them that has nothing to do with this pending case. It doesn't matter. As long as there's something open, then we can't expunge any of those things for them. But as soon as they have that disposition, it is no longer a pending case. You can see here we have a little bit of a gray area where it can be considered an open case, that first year of a stat disposition, which Susan sort of gets to your point about the good faith, right? That first year of the stat really is sort of considered still active, and then an active probation on a probation before judgment.
But if I could add,
Yep.
In those two gray area cases, I file for expungement in that instance, and it's only maybe one or two counties that have ever given us a hard time about calling that an active case. So generally, most courts don't interpret those two examples as being a pending case.
And then the one other wrinkle here we want to talk about is traffic. So this gets just a touch confusing, but it's not that bad, which is that traffic really divides into two kinds of expungement areas. The ones that we care about and the ones that are expungible are traffic cases that are potentially incarcerable. So, and we're going to go over that list in just a minute. So if it's a minor traffic offense, that's a separate MVA expungement, and now MVA has an automatic expungement for most charges, so you don't really have to worry about the MVA piece of this. But there are these major traffic offenses, which we'll go over in a minute, and you want to do that analysis. And in fact, you need to do that analysis partially just to see if you can get something removed from their record. But when you're doing any of that subsequent conviction analysis for a PBJ or any of the JRA crimes that Chris went over, say they have a guilty for a suspended license, that is going to that's going to block a PBJ, or that's going to be considered a subsequent conviction that's going to block being able to expunge something. So you do have to look at traffic cases. And then just this last piece, if it's a minor traffic case that has a conviction, you can just completely ignore minor traffic cases. So when I was talking about, so the person that had a suspended license and a speeding ticket and a no seatbelt, so if their suspended license is no pros, but they got a guilty on their seatbelt, you don't have to worry about that. You're only looking, your analysis, so when you want to figure out, when you look at a traffic case, you know you're going to have 2 or 3 different records to look at, and then you say like, okay, seatbelt, nah, it's not potentially incarcerable, I'm just going to delete that out, I don't have to worry about it. So you want to see what the picture is, but then you can start peeling off things that are just minor traffic cases. And this is on our website. This is the most useful tool. I think we have a lot of useful tools on our website, but this one I go to all the time. And I'd like to take credit for it, but we did not create this. We just thankfully have access to it. And this lists every incarcerable traffic offense. And so when you are looking at a case, it's generally going to have the code, the traffic code, and you just look over at this and just run through the list and say like, okay, 16303 over there, license suspended, etc. So you know then that is a potentially incarcerable traffic offense, and then you've got to do an analysis. Is it a guilty? Is it a no pros? Is it any of the dispositions that we've talked about? Without a doubt, the 2 most common charges we see are suspended license and uninsured vehicle. Those are the 2 that we see very frequently. Again, we're working, for our clients, we're working with low-income individuals that might be struggling to either pay for insurance, or if they have a suspended license, there's a variety of fines and fees that get tacked onto that, and they often get in a cycle where they can't ever actually get those things paid off. And so those are really common charges, and it can be really frustrating because those two, as a guilty, can block some really pretty significant charges that otherwise could be expunged. So when we're looking at a subsequent conviction, or when we're looking at a PBJ, something like a suspended license or an uninsured vehicle absolutely can stand in the way of being able to expunge something that otherwise would be expungible. So we have this posted on our website. Don't feel like you have to commit it to memory, but I definitely would encourage you to just, I just always pop over there just to check myself to make sure that it's one of the potentially incarcerable. And then if it's not on this list, you can just ignore it, because it's not a charge that we need to worry about. Okay, Chris. All right. Everyone's favorite time, test.
All right, so we'll just have a couple examples of different cases and kind of going over all of the rules that we've been talking about and seeing if we can apply them. So imagine that this is a client that you're working with, and both of these cases are the cases that are on their record, and you see that in 2014 that a case with 2 charges, that was second-degree assault and misdemeanor theft. And then you see null pros for second-degree assault, guilty for misdemeanor theft. Then you see another case 3 years later for them with 2 null process for theft charges and motor vehicle theft charges. So if anyone has a guess about what may or may not be expungible in this case, feel free to type it into the chat, or if anyone here in person wants to take a guess at what could be expunged off of this person's record.
What
Go ahead.
when?
And when, yeah.
I know, it all seems really straightforward until you try to start working with it, right? And it does get a little bit. Do you want to start with case 1? Like, what are your thoughts about case 1?
I would say it is not expungible because of the unit rule, because even though there's a null pros, which is immediately expungible, and it's more than 3 years and you wouldn't have to file a petition, the guilty plea or the guilty disposition is less than 10 years, and so you'd have to wait until 11/18 to 2024 before they are both expungible. Is that right?
That's correct. That's 99% correct, I think. I would just add that when you're looking at the 10 years for this guilty, you can actually see that they were sentenced to 1 year and 1 day of jail time. So you actually have to add 1 year and 1 day to the disposition date, and then the 10 years goes. So 11/19/2015 is when the 10 years starts to run. So then 11/19/2025.
Where do you look for the?
So down where you see jail term.
Oh, jail term. Okay.
Yeah.
And then you also want to check probation end date too,
Right.
which is not in here. And just to back up for a second, the reason it's the 10 year, so you have a guilty. Then to Chris's point, you're going to look and see what the charge is. So you see it's theft. So you're going to check that JRA list. And and theft is on there. But then you have to figure out theft has, as Chris has talked about, the misdemeanor theft and the felony theft. And since it's less than, that's generally going to be a misdemeanor theft, which means the 10-year waiting period. If it said more than, then you'd be looking at the 15-year waiting period.
And what you can do to double check that misdemeanor versus felony is just look up the statute. Usually, the line right under the charge usually lists the statute that was cited to charge that person with that particular crime.
So you can see in this one, it's CR 7104.
Yep. And then, assuming that this second case is the only case on the person's record, besides case 1, there would be no subsequent convictions. So that wouldn't block case 1 either. And then case 2, we just have 2 null process. So I'll just go ahead and give you the answer, which is that that case can be expunged immediately. Of course, it's not yet been 3 years, so you would just have to attach that waiver of liability. Here's another quiz question. So you have a case where there's 2 convictions, and then you have a case where there's 2 sets from 2016. And you can see the convictions are possession of marijuana and open container of alcohol. So does anyone have a guess about whether or not case 1 itself would be eligible for expungement?
Got one yes that they think.
Okay. Well, that would be the correct answer. And the analysis would be, you have a marijuana possession guilty, so that's a 4-year waiting period. And then the open container alcohol is a 3-year waiting period for that guilty. So they run together, obviously, so you just wait until the end of whichever one's longer, which is the 4-year, and it's been more than 4 years, so you can expunge that one.
And just quickly, with both of those charges, as Chris mentioned earlier, so the CDS possession marijuana is just 4 years with no further analysis. You don't have to worry about a subsequent conviction. And same with open container, because that falls under those nuisance crimes. So it's just a 3-year waiting period. You don't have to do any subsequent conviction analysis with these.
Right. And then case 2, we have both charges received a stat disposition, and that date was 11/7/2016.
So what do we know about stats?
3 years.
That's right. So 3-year waiting period for a case that received its debt. So it's not yet been 3 years. So next year, 11/7/2019, this case would become eligible for expungement. Let's just keep going. So now we're going to talk a little bit about what the forms look like, what the actual procedure looks like for filing. These are the basic expungement forms. You'll see that the court has broken the whole thing into two forms. One is for all dispositions that are not a guilty, and the other is for a guilty. So you would file a petition for each case that you're trying to expunge. In the instance like Susan was talking about earlier, where there may be multiple circuit court case numbers for one single case, you would actually just put all the case numbers on one petition. So like it says there at the top of the first bullet, is one form per incident. And again, like if you had a bunch of traffic cases that have different case numbers, but it's all the same incident, assuming that they're all eligible, there's no unit rule violation, you would put all the case numbers on one form. So you might come across an instance where like you had a PBJ and a null pros in one case, and if it's eligible for expungement and you're going to file, you can just check both. It's a check all that apply scenario when you're filling out that form. And then if you were to have a case where, say, you had like an assault second degree guilty, and then you might have had like a theft null pros in the same case, and it's been 15 years, you would just file the guilty form, and you would just check off whatever box applies to the guilty, and just ignore any not guilty dispositions in that case. We will talk a little bit later about our Chrome web tool that helps you fill out these forms. I would emphasize now that that tool does check the appropriate boxes for not guilty form. However, it doesn't automatically check the guilty box. So you have to go in and make sure that when you're doing your final review before filing, that you have the appropriate box checked on all forms. This is the fee waiver form. If someone were to file for expungement of a case that does have a conviction, it would ordinarily cost that person $30. If you're representing a client for Maryland Volunteer Lawyer Service, we are eligible to get an automatic waiver of that fee. So you would just file this form, filling out the case number, client name, your information, and sign it. Our Chrome web tool does generate this form automatically for you, and it knows when you would need it, which is in the case of a guilty. Right now, there's a little bit of gray area about circuit courts requiring that fees be paid or a fee waiver be submitted in all cases, not guilty or guilty. Baltimore City does not do that. Baltimore County does not do that. They only require it for guilty. I can't speak on any other county. For most of this year, most counties have been asking for that waiver at circuit court in any scenario.
And just when I file, I just file the fee waiver. Just there's no harm in filing it. So if it's any conviction in a circuit court, I just go ahead and file it.
So this is what that liability waiver looks like. Again, our program that we'll talk about later, the Chrome web tool, does know when to generate this. If it's been less than 3 years for an otherwise eligible disposition. You don't have to have this form notarized or anything. The first blank is the client's name. Then the next blank is usually the arresting police officer, which is information that is contained on case search when you're looking at that particular case, and then the law enforcement agency that arrested the person. As a quick note, if you're looking at a circuit court case, usually that law enforcement and arresting officer is not available in that docket on circuit court on case search. So you would go to the district court case where the case started to find that information. And almost always the district court case is listed, the case number is listed under the circuit court number on case search. So you would have the client sign if they're okay with waiving that potential claim, and then you can sign as the witness or anyone else who might be there to sign as the witness. So this is what we recommend for filing these cases. Once you're all ready to go, they're signed, they're correct, they're ready to go to the court, scan those filings just to make sure you have a record of what's been filed, then make 3 copies of each petition. The court is required to serve the state's attorney and the police department that arrested the person with notification that expungement has been filed for. So they send 2 of those copies out to those agencies, and then we highly recommend requesting that final copy be sent back to you with a date stamp as proof of filing. Because this process can take so long and is different in every courthouse, and as far as how long it takes, one of the most important things is getting that date stamp copy. So just asking for it in your cover letter, and then keeping track of the cases that you filed and whether or not you've received a date stamp copy. There could be an instance where it's been up to 6 months since you filed and nothing's happened yet, and then you can call the court and they might say, well, we don't have the expungement or something, they lost it or something's gone wrong. If you have that date stamp copy, you can go back and say, you know, I have proof that this was filed 6 months ago.
And just to be clear, this happens with some regularity, so that's why it's so important. It is not uncommon for a court to lose an expungement petition.
Right.
Some courts. So
Yeah.
For some of the high volume courts, it's not unusual for them to lose a petition.
And then if you're filing in a county that uses electronic filing, which is most counties now, although Baltimore City is not one of them, you just file it like any other electronic filing. You just put the petition, upload it, and file it. Now, if you have something like the fee waiver that's required or the liability waiver, if that's required, they like it if you upload each one as a separate document and title it specifically with what it is. Your filing could be rejected if you just put all 3 in one PDF and sent it in. And then the only other thing to worry about with filing for MDEC is that you do have the opportunity to check parties to serve. So you can search for the county, the state's attorney of the county where you're filing, and just click that email address, and they'll get service.
And that link walks you through how to file an expungement petition on MDEC.
So the time frame for getting a case actually expunged is through the entire process. The statute says that once it's filed, the state's attorney has 30 days from when they receive it to object based on any law or any reason that they have that they think it shouldn't be expunged. And then if no objection occurs, the court's supposed to grant the expungement. Due to high volumes of expungement and any other reason that would delay the process, currently there's no court that we're aware of that actually would turn around an expungement in 30 days. Most courts would take at least 4 months to actually get it turned around. Baltimore City District Court is going to take at least 6 months to complete the entire process and actually send out an order for expungement. In circuit court, generally the process is going to be faster, oftentimes much faster. Even Baltimore City Circuit Court could take maybe 3 months to turn around the entire process and actually get those cases off case search. But what we recommend is noting the time that you file, maybe set a calendar alert or however else you like to remind yourself of something for 6 months after you file. And then once that goes off, you can go back through all the cases you filed and see if they're off case search. If they're off case search, then there's really nothing to worry about. You're just waiting to get the actual paperwork in the mail confirming that it's been expunged. If they're not off case search, you haven't gotten any paperwork, I'd recommend calling that court and seeing what's going on. In the case that you do get an objection from the state's attorney, most of the time the court will file a hearing, will schedule a hearing. That's what they're supposed to do according to the statute. And the state's attorney is also supposed to serve you with their reason for why they're objecting. Most of the time, if you're getting an objection, it's valid. It could be a mistake in filing could happen where there was a subsequent conviction for a PBJ and you didn't see that when you were doing your analysis. A lot of times we see things like the client's name was misspelled in case search and you never saw that subsequent conviction, so you just didn't see one. You filed in good faith thinking that it was eligible, but it turns out that there was something blocking it, lurking on case search that you just weren't able to see. And then when you find out, you review the case, the objection, and you do have the opportunity then to just say, well, this, I agree, this can't be expunged, and you can file a motion to withdraw and ask the court to cancel any hearing that may have been scheduled. You might get the objection a week or even a few days before the hearing has been scheduled. In that case, you probably won't have time to actually withdraw, so you will have to go to the hearing, unfortunately, and just ask to withdraw or just allow the petition to be denied if, in fact, that objection is valid and the case really is not eligible. So 4 months, 6 months after you filed, you start getting some paperwork in the mail. First, you usually get an order for expungement, just saying that the court has granted that request. And then after that, you start to get some other papers from different agencies called certificates of compliance. Agencies like the court itself, the police department, they have their own records of the arrest and anything else. Pretty much any record-keeping agency that touched the case is supposed to file their compliance with the court saying that they have followed the order to expunge. They've gotten rid of record of that case. So what I do when I'm working on a client's file, I collect all of those, scan them in as I get them. Once I've gotten confirmation for every case that I filed, gotten the compliances from all of the relevant agencies, then I'm ready to close the file. I take that stack of papers and send it out along with my closing letter. Now, the court does send paperwork to your client as well, since their address is on the expungement petition. But just to make sure that they're getting everything that I'm getting, I always just send any copy of what I've gotten to them as well.
And that one additional point that Chris had on there, make sure you go into Maryland Judiciary Case Search. Sometimes you'll get an order, but the clerk forgets to take it off of Case Search, which defeats the entire purpose of an expungement.
Yeah.
So just make sure it's been taken down. And if it's a circuit and district court case, you filed in the circuit court. I guess we didn't really talk about that today. When you have a case that goes to circuit court, you file in the highest court. And so they remove it from circuit first, and then circuit court has to tell district court, and within 30 days, they're supposed to take it down. So you want to check both places because sometimes it just misses. The other thing is it's just a good final check because every once in a while I'll find something that I missed, or the law has changed again, and all of a sudden something that a year ago wasn't expungible now can be expungible as well. So it's always just good to do a final check before you close the case out.
Right.
Chris, we are almost out of time.
Okay, so hurrying up, I've been mentioning this Chrome web tool, mdexpungement.com, and the corresponding Chrome plugin that you can add to your browser is a tool that a former staff member here developed that helps you do this analysis. If you have the Google Chrome web browser, you can install this program. It adds a little button to the top of your screen. If you're looking at a case on Maryland Case Search, you can click that button. It will tell you if the case is likely expungible or not. You should always do your own analysis as an attorney. And it actually allows you to create a little docket to add all the eligible cases and then click a final button that will actually generate the forms all filled out properly, with the exception of those convictions. You do have to manually check that form.
I think that's back to me.
Yeah.
So yeah, with MD expungement, it as Chris is saying, it does a great job doing the analysis for the non-convictions, but particularly for anything where you've got to factor in a subsequent conviction, it's not going to pick that up. So you really got to do that your own analysis, but you can use it to prepare any of the forms, whether it's a non-conviction or a conviction. Just on the conviction cases, you just need to make sure you check the box because it's not going to show up there. But it's a super time-saving tool. So speaking of time-saving, we're going to zip through this last part here. Oh, look, we were ahead of ourselves. We did talk about this. Okay. So these are just a few tips about case search, because case search can be its own sort of special place to do some research and analysis at. So these are just a few tips. So one, if you're looking at a case, a district court case, and you see this down here at the bottom right, you see there's no disposition. When there's no disposition, you either need to be looking at saying, is this an active case where there hasn't been a disposition found yet, or did this get transferred over to circuit court? So there's a variety of cases, particularly if it's going to go to a jury trial, it's going to get transferred. And so you can see up here on the top, the case disposition, which you will find at the top, will say forwarded to circuit court. The other one that you'll see pretty consistently is jury trial prey. And so you've got to go find that circuit court case and then see what the disposition was in that circuit court case, which will then tell you whether it's expungible. And then you're going to, if it is, expunge both the circuit court and the district court case. So that's one of the tips when you're looking in case search. You want to look whether it was forwarded or not. So here's a few tips. So do not add a middle name or initial. And the reason you don't want to do that is many clients, the records don't include their middle name or initial. So you want to search broadly and then narrow it down. So like say, I'm looking up Chris, maybe all of those records are just going to say Chris Sweeney. They're not going to say, Chris, what's your middle initial? Okay, so then there isn't always going to be an M there. So if you put in that M, you're going to miss all the ones that Chris might show up because it doesn't have that initial. This was Matthew's tip to select defendant as party type. Chris and I neither use that. We leave it really open to try to make sure we're capturing everything. And then you can also, if someone's got there's a variety of misspellings in case search. I find, and I imagine Chris has this experience, the more unique a name is, the more misspellings that we find around that name. So sometimes I'll search like just the last name and maybe the first two letters of their first name. I'll try a couple of variations to try to make sure that we're capturing everything. The other thing, in terms of the common name, given how common the name is, that gives you some flexibility to figure out how you want to search terms. So I looked up, so if you look up Susan Francis, there is 6 criminal records. So I could play around a fair amount with that because there's not a lot of records. Chris, has been far busier than I have been. If you search Chris Sweeney, there's 30 criminal records. So again, you have some room to play around with searching. If you search John Smith, there's over 500. So it's impossible if you have a client named John Smith to find all of his records on K-Search, because not everyone's going to have the birth date. They're certainly not going to have the middle initials. So what we do when we have a client with a very common name like that, we're going to match everything we can with their birth date. And then I'm going to ask them, or I'm going to say, this is the best I can do because your name is so common, it's impossible for me to find everything. If you really want to make sure, you're going to have to go get fingerprinted and get, we call it a CJIS. It's the Criminal Justice
Information System?
Yes, and we have information about that, about how they can go do that. Essentially, there is a location off of Reisterstown, and it costs them $38, or they can do it at their local police department. And there's other kind of fingerprinting businesses out there. But if we have someone with a common name like that, like, it's just not going to be possible for us to get all of that analysis. And then also just check with the client. Sometimes clients will be like, I have no idea what's on my record, and other clients know exactly to the day, exactly what the charge is. So I always just check with them to say, have we found everything? So here, this is, once you've so if you put in, say, Susan Francis, and then you can sort it by date of birth, which is my preference, and I think that's Chris's preference as well. And so you're going to immediately know, and that you can't assume you've matched everything by their date of birth, because sometimes it's missing or it's entered wrong. And so you want to go through and look at them and then see what else you can match up in terms of timing, in terms of location. You know, if I've got a client down in Wycomico and it's missing, or the birth date's off by a year, or it doesn't have a birth date, but it's in Salisbury, like, I'm going to go ahead and look at those and just make sure I've actually found everything that we can for that client. And let's see, what page are we? The other thing that I do, these were tips this is how I do this process, is that once I found them all, so say Jane M there, so there's 3, I go up and I open each one, I print them out, and then I organize them by filing date. And then I just work through each one, and doing it by filing date is going to help you if you have to look at subsequent convictions. And so I'll just print them, and then I just work my way through each one of them to figure out what is and isn't expungible. And then, as Chris has said, I always set my calendar for a 6-month review. And then, Chris, did you want to mention quickly about your opening cases and the separate tabs?
Sure. Just as another example of how to just go through this process, what I do is once I have all the client's cases sorted by date of birth, I open every case in a separate tab. I just pop them all open, and then I just go through each one, and I take all of the easy ones like null process and other things that I know are definitely expungible. I add those all to my little tool and just close them out, and then tackle some of the more complicated ones like a conviction, and then start looking for subsequent convictions and just start to narrow it down that way.
So yeah, there's no right or wrong. It's sort of figuring out what works best for you in terms of the logic of kind of tracking each potential case. Okay, home stretch. So with the training today, there is a case requirement. So we're going to just quickly talk about different ways that you can take cases. So we do offer expungement clinics from time to time. Most of those are sponsored by law firms. However, we do have a clinic coming up on February 27th, and I'll show you that on the calendar at Bon Secours, which is here in Baltimore City on the west side, and it's part of the workforce development work that they do over there, and Chris and I will both be at that clinic. Another way you can volunteer is through our Wycomico cyber clinic. So this is kind of a neat partnership we have with the Salisbury Public Library, where the clients are in the Salisbury Public Library and the attorneys are here in our office at MBLS. And we do it through Google Hangouts. And the process is just like any other clinic. And you do the analysis. We send a link over to the clients at the library. They print out the petitions there, they sign them, and then they send them back to us. So it is just like any other clinic. We just happen to do it remotely. So that we do that every other month on the second Wednesday of the month here in our office. So our next one's next week, but it's from 2 to 4 p.m. every other Wednesday in December, February, April, June, just the every other month time period. And we're always looking for folks to help us with that. The clinic's actually open for any legal issue, but staff attorneys handle all the other legal issues. We're just looking for volunteers to help us with the expungement questions that we get. And most of them are expungements. It's a partnership with their employment center within the library. And then you can always take a case from us, and I'm going to show you the cases we have available on the portal. So that's another way. And then sometimes we have pre-completed petitions where we might have a clinic where the attorney couldn't take the case, and this comes up most often if we have someone from the Attorney General's office assist at the clinic. So they are not conflicted out of the clinic, but they're conflicted out of filing the petition. So from time to time, we will have these petitions where an attorney's already met with them. We just need someone to double check the petitions and then file them for the client. We do have a variety of trainings, and I'm going to show you those really quickly here. This is our contact information. Chris and I are both more than happy to answer expungement questions at any time, at any point in the process. If you're not sure, please feel free to reach out to either of us. So I'm just going to show you this actually on our website. I will say we didn't talk about shielding today. That's another kind of sliver of the work that we do here, and we do have a free training coming up on January 17th as part of our third Thursdays, and we would welcome you to join us in that. And let me just jump over really quickly here. We offer, this is on our website, these are a variety of resources that we have. All of our recorded trainings, this training will go up here. We do have a variety of information, like here, how to file an MDEC, but then we also have by subject matter. So if you go over here to the expungement section, this is the MD expungement website we talked about. This is today's presentation. We have these flowcharts that will help you do your analysis. So if you know that you have a conviction, you can just work your way down this flow chart. And we have the same thing for the non-conviction as well. Here's the instructions about how to file an MDEC. This is the JRA convictions that we talked about, and this includes, these are the most common ones, the ones that we were discussing today. And then this is the long list of all of the ones. But if you're like, oh, I just can't quite remember, it's all listed right here. This is, if you really want to read like an exciting 400 pages of the Justice Reinvestment Act, you certainly can. And then this is this incarcerable traffic offenses list that we mentioned today. And then there's just some helpful, this is if you want to volunteer, like for our bond support clinic, and hopefully, let's see if it's, this should be for our next bond support clinic, but that's where you can do your registration at, or you can just send me an email. This is some helpful tips about old cases, and then this is some of our short videos we have about different hearings. So this is all on our website. We do have a variety of trainings coming up. This is our events page. And I just wanted to mention, we have, in addition to the shielding one I mentioned in January, we have a bankruptcy training in January. We have an estate planning and administration training in February. We have a couple of third Thursdays. We have a third Thursday series that are all free. There's no case requirement. We have one on December 20th about leaping common hurdles in solo practice. We have our shielding one coming up. We also have one on family law issues in February. We thought, February being the month of love and Valentine's Day, we would talk about non-love, I guess. And then we also have a Tax Tuesday. And then finally, I just wanted to show you quickly our portal, which is where you can take a case from us. And so if you go to our portal, you can search all the cases, but specifically our expungement cases, you can just click on expungement. And then, so these are the cases we have available right now, but you can see it includes the location of these cases. And I will say some of these that are more remote out, Chris and I and others often handle outline, like we do a lot in Wycomico, for example, and we handle everything via mail. So you don't necessarily have to do any traveling between you and the client. So mail and phone calls. But when you're ready to accept a case, you just click on Learn More, and then just put in your name and email, and that will go off to the appropriate paralegal who will follow up with you. We're a little bit over, but let me pause there. That's everything that we had to discuss. Are there any final questions, either for those on the webinar or folks here? Anything we didn't cover? Anything you want any clarity about? Any questions? You guys feel like you got it all? Got it all? Okay, no.
I have to.
You really do have to do
I have to
it.
see it.
Once you do a couple cases, then it really starts to click.
Yeah, and I would say really, use these materials. These materials really are very helpful. Like I said, the presentation from today, so you can go in and see everything that we outlined about the different waiting periods, use the flow chart, use the incarcerable traffic offenses. The nice thing about expungement is about 95% of expungements are very clear. Like we know exactly whether it's expungible or whether it's not. And then there's some that are a little bit more nuanced. And again, in both of those cases, whether it's clear, but you just, it's not uncommon for someone to say, like, I've done the analysis, I just want someone to just double check. It's my first time doing one. We're happy to hop on and take a quick look at case search and just sort of navigate that. We can answer questions about MDEC, or we get some really good questions where Chris and I have to scratch our heads a little bit and think about, what we would think. So we're always here as a resource. I don't see any questions on GoToWebinar. So I think with that, we will end the training and thank everyone for participating. Encourage you to sign up for that February 27th clinic or our Wycomico Cyber Clinic, or take a case through our portal, and just, reach out to Chris or I if you have any questions. Thank you for participating.
Thank you.
Okay, I want to do this. Yeah.